its review of the Conflict of Interest Act.
Our witnesses for today, from the Office of the Conflict of Interest and Ethics Commissioner, Conrad von Fichtenstein, who is the Commissioner, Lynn Robinson-Dalpe, who is the Director of Advisory and Compliance, and Michael Aquilino, who is the Legal Counsel. Welcome to committee. Commissioner, you have up to 5 minutes to address the committee. Go ahead, sir. Thank you.
Bonjour, je suis heureux d'être ici.
Good morning. I'm pleased to appear before the committee during its review of the Conflict of Interest Act for appointed federal officials. And you have already introduced the people who are with me.
In this review, in the past 18 years, there have been just a few minor amendments to address specific matters. The Act has been working quite well since it took effect in 2007 and met the purposes set out in Section 3. There is, however, room for improvement. We have identified 6 legislative changes that could make the administration more efficient. Premièrement, ces modifications ne viennent pas.
They are based not just on my own experience as a commissioner for over the past 2 years. They also reflect the experience of the Commissioner's Office in administering the Act for almost 2 decades.
Canada Act, under which a commissioner is appointed, it would let the lobbying commissioner step in temporarily if there's no conflict of interest and ethics commissioners. While the Commissioner's Office can manage day-to-day administration of the Conflict of Interest Act, only Commissioner can exercise the discretion given in various provisions. The other 5 amendments concern the Conflict of Interest Act. Premièrement, ajouter les conflits apparents.
1. Add apparent conflicts to public office holders' general duty to arrange their private affairs in a way that prevents conflicts of interest. This would make the Act more consistent with the Conflict of Interest Code for members of the House of Commons and the ethics rules for federal public servants. 2. Allow some assets to be designated as exempt assets if they pose no risk of conflict of interest. The Commissioner has no discretion to exempt any assets from the Act's blanket prohibition on reporting public office holders owning controlled assets.
Traded funds is a perfect example of that. 3. Allow public officers to participate in matters affecting the private interests of their friends and relatives if those interests are the same as those of other members of a broad class of which they are part. This would make the Act more consistent with the Code. 4. Let the Commissioner approve outside activities that don't conflict with reporting public office holders' official duties. The Act restricts activities that are not part of their official duties. There are some limited exceptions, but they don't cover many activities that would not cause a conflict. Teaching is, for instance, a perfect example. And 5, raise the maximum administrative monetary penalties. This is not to make them more punitive, but to stress the importance of meeting the Act's reporting requirement. These recommendations are discussed in our last annual report under the Act. As the committee will recall, I also mentioned them during my last appearance. Nous avons suivi les travaux du
We have been following the committee's review of the Act and the testimony of other witnesses. Some interesting points have been raised about enhanced education, increased transparency, and greater accountability.
You may have about my recommendation or those of others that appeared before the committee.
Okay, thank you, Commissioner. We'll get right at it. 6-minute round starting with Mr. Barrett. Go ahead, sir.
The Liberals' Bill C-15 creates a new power for ministers to exempt companies from federal laws, and this can be done in secret. This opens the door to conflicts of interest that Parliament and your office might never see. If a minister can grant exemptions and they can be granted to companies that they are connected to, and even conceal their orders from public release, won't this at a minimum make it harder to detect that a conflict of interest exists, but doesn't it also create the opportunity for real conflicts of interest to occur with no effective oversight whatsoever?
Just because the minister is authorized by statute to do something doesn't mean he can avoid the conflict of interest to act. So if it is part of his function to exempt the company, he can do that. If there, however, is under the act a conflict of interest, as you suggest in your example, then he has to recuse himself. The act is quite clear. He cannot participate in the decision. He can't even be in the room. He has to leave and absence himself when that decision is made.
It appears to be a systemic gap that's being created, though, Commissioner. It's a path for ministers to bypass the usual parliamentary safeguards and ethical scrutiny by shifting decisions into private exemption orders. Does that not present a cause for concern for parliamentarians?
I'm not sure I follow you. How, Mr. Barrett, where is the shifting taking place here?
The effect of their orders is not public, and they can exempt the normal release of information that we would see, and it's for a period of years, and there would be no detection that it has occurred. So we assume that the minister leaves the room, but oftentimes we find out only that a breach has occurred because of the release of information, access to information requests, inquiries of ministry, order paper questions, and the like.
When you say the exemption is secret, you mean the Act authorizes the minister to make a decision and it not to publicize it?
The information does not need to be publicized in the Gazette.
Yeah, but I'm sorry, if the company is exempted, that means if they weren't exempted, they couldn't do this. So presumably, the exemption has to be published somewhere.
Well, one would hope that through the transparency that's required, then yes, but that's not the effect of the Budget Implementation Act, Bill C-15. Your question, your question that I've provoked is born out of the same expectation I think that Canadians have about transparency and openness that we expect from government, when instead there's we're moving off the path of normal government and into exemptions to all laws except the criminal code is what the Act says.
Okay, well, first of all, C-15 is not law yet. It has to be passed by Parliament. Secondly, the obligation not to act in contravention of the conflict of interest is there. The minister cannot make such a thing. Now, you posit that he will make an exemption which benefits himself and people do not know about it. I mean, sorry, I always have difficulty answering a hypothetical question. If you give me an actual case and actual facts, I can answer that. I don't quite see how we can have a secret exemption. The effect of the exemption will be public, and people will ask, like you, why is this company doing it when normally an act would require A, B, and C? Where do they get the authority?
To be clear,
so therefore, somebody will say there is an exemption. Here it is.
So to be clear, I don't see the mechanism in the legislation that would publish the exemptions that are able to be made to all laws except the Criminal Code, including the Lobbying Act, including access to information laws, and including the Conflict of Interest Act. But am I to understand then that the law as it's written, and should it come into force, without giving any hypothetical examples, that it gives no rise to concern for you?
The Act, Parliament has the authority to enact what they want. As you know, the Parliament is supreme. And if they will act that, we will look at the Act. I have not looked at it from this particular aspect that you mentioned, but I cannot understand the rationale how you can have an exemption that is secret and will not be. It's, after all, it's an authorization. It has to appear somewhere.
Well, the expectation I think that Canadians have is as Parliament is supreme and has passed laws, including the Conflict of Interest Act, the Lobbying Act, access to information laws, that there's no reason for a government to put forward legislation that gives them the opportunity to exempt themselves from all laws except the criminal code. I think that Canadians should be rightly concerned, and I certainly am.
Okay, thank you, Mr. Barrett. Madame Lapointe, pour 6 minutes, s'il vous plaît, commencez.
Ms. Lapointe, you have 6 minutes. Thank you, Chair. Welcome to all of you again to the Ethics Committee. In your opening remarks, you mentioned listening to the previous testimonies. I imagine that you paid attention to Michael Sabia's and Marc-André Blanchard's testimonies. And following those testimonies, they talked a lot about blind trusts, but also the screen. I would like to know what you think on this ethics screen. Are you satisfied with its operation by the Director of Cabinet as well as the Chief of Staff? This is a method that was approved by the Federal Court of Appeal. It helps with the administration of the Conflict of Interest Act. That screen is a preventive tool. We want to ensure that there isn't a conflict of interest, whether it be for a prime minister or others, and they would need to recuse themselves. And those who are responsible for the application of the screen and documents that have to be given to the Prime Minister, they need to see whether or not there are any issues that would lead to the Prime Minister recusing himself. If they detect anything, they will avoid such a decision being put in the hands of the Prime Minister and give that to another minister. The Prime Minister will be informed once things are implemented and will not be able to make any changes on that decision. I believe that it is a preventive measure that was approved by the Federal Court. Mr. Sabia and Mr. Blanchard are the two people who are responsible for the documents that arrive on the Prime Minister's desk. They review all of the documents closely before they are given to the Prime Minister, and they verify whether or not there is a possible conflict of interest. If there is a potential conflict of interest, the document is not given to the Prime Minister, and the Prime Minister's office explained the process. And from what they've said and what they shared during their testimony indicates that the tool works. Thank you for that. Mr. Sabia and Mr. Blanchard also stated that they have a table that allows them to make decisions to see whether or not documents need to be included in the screen. They also mentioned that they are constantly working with you, and I would like to know how that works. So both of those witnesses stated that they are constantly working with you, and I would like to hear more on that, please. As you know, I have to give advice to those who are subject to the Act. The Prime Minister is subject to the Act, and if there are any issues, they can communicate with us. What advice we offer is confidential. We have a dialogue, yes, but it is initiated by the offices of Mr. Blanchard and Mr. Sabia. If there is any kind of doubt or any kind of unknown, they will call us and we will give advice. Another thing that we learned through them is that they were responsible for the screen, but they were not responsible for the blind trust. That is outside of their scope. I would like to know what you think on that. The Prime Minister put all of his assets in a blind trust. He cannot touch that. He does not speak with the trustees. But he knows what he put into the trust. If there's a decision made regarding a specific company, there could be known benefits because those assets will increase. That's why the screen is there, so that he cannot make a decision on something that would have an impact on the value in the blind trust. He only knows what is in the blind trust initially. He gave a list of all of the assets. It's been put in the blind trust. He cannot touch it. And then there's the screen in order to prevent any decisions being made that would have an impact on that. Thank you, Mr. Commissioner and Ms. Lapointe. Mr. Thériault, you have 6 minutes. Thank you very much, Chair. Welcome, Commissioner. Welcome to your colleagues as well. With all due respect, I would ask that you can respond in English if you'd like. There are some nuances that are important, and perhaps your French might not reflect those nuances, and I know that our interpreters do a very good job, and you can respond in English if you'd like. When Mr. Sabia came to the committee, he talked about the screen and the table that they use. And when he was here, I asked if there was any accountability that needed to be done to the Office of the Commissioner. He said that it was not necessary because there is constant collaboration and total transparency, and that he shared the entirety of the activities with the Commissioner's office. I asked questions to Mr. Blanchard as well because Mr. Sabia's answers led to more questions. He said to committee that he was in frequent communication with you and that you were contributing to their analyses. I am a little bit perplexed because I had asked you a question previously on accountability because I found that this screen should be managed independently, and I was suggesting that perhaps the Commissioner's office should be responsible for it, and in answer, you told me that it would lead me to be in a conflict of interest, that I cannot be judge and jury. If I participate, then I would be the one making a decision. So I would like to know whether or not there is really accountability, and regarding your contribution to the tool or to the screen, is it really that frequent? Firstly, you stated that we participate in the analysis, and that's not exactly the case. We give advice. They do the analysis, and they make decisions. Our job is to help them. What is the frequency? How often? They say that they communicate constantly with you, and so there is no need for any accountability. They decide how many times to reach out to us. Ms. Robinson-Dalpé is responsible for that, so perhaps she could give you some additional information regarding the mechanism. Thank you, Commissioner. As the Commissioner said, the office, and it happens often that we receive requests to give advice on specific situations. I can't give you a specific number. That said, it does happen regularly. Just as is the case for other public office holders who have to be subject to the screen, the Commissioner can be consulted regarding its application. I don't have any specific data, but it is frequent. Is it frequent enough to require no accountability? That's the question. The administration of that assessment tool and the application of the screen makes it so that you have frequent communications, so frequent that there is no need for accountability. You're aware of everything that's being done as decisions are being made regarding the application of the screen. Is that what we should understand? In most cases, I would say yes, we are aware of the situation. So you approve what they're doing. I can't say that we approve. As the Commissioner said, we give advice on a given situation. We share additional information with them, but in the end, it is up to them to make a decision regarding the application of the screen. And it's up to the public office holders to recuse themselves if there is anything shared by the screen and the administrators of the screen. But for them, applying the screen is so complicated and complex that they need the guidance from the Office of the Commissioner at all times. Would it not be simpler to have an independent person responsible for the application of the screen? You have 35 seconds. In that context, unfortunately, at the Commissioner's office, we don't have people at every organization who could help with the application of the screen. But here we're talking about the Prime Minister of Canada who makes legislation, and as the Commissioner stated, there wouldn't have been a screen without even an appearance of a conflict of interest. We're not talking about any old public office holder. Mr. Thériault, unfortunately, your time is up. Perhaps you can come back to your question during the next round.
Starting, go ahead, sir.
Thank you, Mr. Chair. Welcome, Commissioner. Welcome to your team. Mark Carney's ethics screen that you set up lists 100 free companies, almost all of which are Brookfield companies. The chief operating officer of Brookfield, Justin Bieber, told this committee that Brookfield owns 2,000 companies and businesses. Do you have a full and comprehensive list of all of Brookfield's companies and businesses?
We have a list of what the Prime Minister and his lawyers furnished us, and it is attached at Annex A to the screen.
So you do not have a full list of the 2,000 Brookfield companies?
No.
Okay. So Mark Carney holds stock options and deferred share units in Brookfield, potentially worth tens of millions of dollars. The chief operating officer of Brookfield said that in respect of Carney's stock options and deferred share units, quote, as the value of Brookfield increases, the value of those instruments increase. So accordingly, it follows that as Brookfield-owned companies do well, Brookfield does well, and by extension, Mark Carney does well. So if you don't have a full list of the companies, I would put it to you that you are missing potentially a whole long list of conflicts of interest or potential conflicts of interest that Mr. Carney has with Brookfield companies.
The Annex A to the screen lists the first five companies. This is really the ones who own all sorts of other, the rest of those, directly, indirectly, or in which are dealing with those. It's clear that Mr. Carney's compensation is tied to the future compensation is tied to the success of Brookfield. But in order to avoid that he makes decisions which can be seen to benefit Brookfield and thereby indirectly himself, he has set up, first of all, he's put everything in a blind trust, but secondly, he set up the screen to make sure that any decisions that he makes regarding the 5 key holding companies, he is, or the ones that he knows about.
Commissioner, I think you said it exactly right, that Mr. Carney's portfolio is tied to Brookfield. As Brookfield does well, so does Mark Carney, and yet 95% of Brookfield companies are not subject to the screen. How do you explain that?
I don't know where you get these 95%. What you have before you is his statement saying these are the companies that he knows about, and etc. And then the entities that appear before the lobbyists, and also the entities that were defined by our office, etc. That's essentially the universe we know about, and as he himself says in Annex A, in Item C, that I had no role in managing them and no direct financial interest in them. So now you're saying he has a financial interest. I don't know how you are you contradicting the statement made in Annex A?
I'm simply referencing what Mr. Bieber said, and in light of the fact that Mr. Carney has stock options and deferred share units, and I know that we saw a letter from Brookfield today that merely dismisses these companies as de minimis. Are you just taking Mark Carney and Brookfield at their word, or have you sought to get further information, given Mr. Bieber's testimony that there are these 1,900 other companies? Are you going to go back to Mr. Carney and go back to Brookfield and say, provide us with a list of those companies to determine whether or not additional companies should be added to the screen?
Lynn, do you want to answer that?
So, essentially, when the screen is a preventative measure, it's there to anticipate conflicts of interest. It's not there for the Prime Minister to avoid a conflict of interest. So, for all intents and purposes, if a matter is brought to the Prime Minister's attention, and the Prime Minister is aware that it would further the private interests of Brookfield, then he would have to recuse, even if the screen did not capture that item because it's not on the annex.
I understand how the screen works. Yeah. I'm just asking, why will you undertake, or are you intending to get a list of those companies in light of Mr. Bieber's testimony? That was my question.
Okay.
Well, of course, we looked at these companies and to make sure we know what the interest of, and most of them, as Mr. Bieber said, are de minimis.
Okay.
But any kind of deferred compensation that you
are taking Brookfield at their word.
I'm going to have to cut it off there. Mr. Saini, you have 5 minutes. Go ahead, sir.
Good morning, and thank you for coming. Mr. Cooper had made statements which are contrary to what Mr. Bieber has said. Mr. Bieber said, yes, they may own 2,000 companies, but only 105 of them are directly related to the conflict that it could occur. So for Mr. Cooper to continue repeating something that he was told is not correct. Not only that, the other 1,900 companies, they are not even in Canada. They are all over the world. They are limited partnership who own their own assets and do their own thing. I would like to hear your comments on that.
Well, what you said is absolutely correct. What is listed here, as he said, the companies which he had a management position or oversight role, these are listed there. The first 5 are the key. Everything after 5 is really part of the Brookfield Global Transition Fund, and And then in B and C are those which we came up with by looking at the lobbyist registration and by looking at the web and seeing what there is about Brookfield owning. But all of these are minimal in then some of them may operate in Canada, some of them may not. The key are the first 5 companies on Annex A, and what follows underneath is really an elaboration of the Brookfield Global Transition Fund. So whether they operate in Canada or something else, they are, as you suggested, they are limited partners, there may be small interests, there may be some tie-up, etc. This is not something that's going to have any impact in terms of conflict of interest. But he has, out of an abundance of caution, he has disclosed as much as he can, as much as he knows, and he put it in the annex.
Thank you. One of the things, the duty of this committee was to bring some changes if we felt. But it has become, in my opinion, just Prime Minister's conflict of interest is the main thing, rather than looking at the broad aspect of what can we do for Canadians. And this is very shocking. We have heard testimony from quite a few witnesses that said Canadian ethic laws are one of the best. They are gold-plated, and even the appeal court has said this is working very good. I'd like to hear your viewpoint on those.
Absolutely right. We are considered the gold standard in terms of conflict of interest, the way we handle it, the way we insist on disclosure, the way we verify, and the way we make public any breaches of the enclosure. The reason I put in my annual report 5 changes just to make the act a little bit more easy to administer and smooth. For instance, exchange-traded funds are controlled assets. Somebody who's appointed or elected like you is not allowed to own them. Why not? How can you influence anything by owning exchange-traded funds? They are in effect the same as mutual funds in terms of their affair. But at the time the act was drafted, there were no exchange-traded funds, so that's why it's not listed there as something that you may own. Another one is, for instance, you may not be employed or do anything outside of your job. There are lots of people who want to teach, even pro bono, at the university, share their opinion, etc. But they can't do that, because in order to be a teacher at the university, the union insists you be employed by the university, and then you're employed and you can't do it. But why not give the media the discretion to say, is it relevant or not? If it's not, but it benefits the public, like my teaching example, by all means go ahead. This is the sort of thing we should be doing here, trying to make the act a little bit more easy to use, and both for the users and for me as administrators, because you want to be able to attract good people into the public service and to minimize the conflict of interest if it's irrelevant.
Thank you. You have stated in your opening remarks that you are recommending 6 changes.
Yeah.
Are you also suggesting any legislative changes that should be done? If so, could you give us an opinion or give us your remarks?
Well, those changes I suggested require legislation, and in my annual report I actually put the proposed changes to the Act in the report.
We'll keep it at that. Thank you. Thank you, sir. Monsieur Thériault, 5 minutes.
Mr. Thériault, you have 5 minutes. Thank you, Chair. Mr. Commissioner, when you appeared before the committee in September, you stated that you wanted to avoid a situation where Mr. Carney would be making a decision knowing that it would increase the value of one of the companies that he has divested from, and that is why the screen was implemented. The Clerk of the Privy Council and Chief of Staff will verify whether any decisions would have an impact on any particular company. If the decision is of general application, then the Prime Minister would not need to recuse himself. When I looked into the tool used for this screen, I noticed that there are shortcomings in the application made by Mr. Sebia and Blanchard. For example, with C-15, for the budget bill that was tabled in the fall, tax credits were added that did not exist for small nuclear installations, and there was another tax credit for clean energy that includes those nuclear facilities. In the tool, it is stated that you need to be aware of Westinghouse, and that was at page 3 of the. In the tool, it is stated that you need to be aware of Westinghouse, and that was at page 3 of the tool. They stated that they hadn't applied the screen because it was a decision of general application. But when we look at the definition on page 5 in that document, it states, if the decision has to do with an indeterminate group of people or companies, well, then it is a matter of general application. There are only 5 players for these small nuclear installations. On page 6, it states that if it applies to a large category, if the decision applies to a small group, well, the matter does not apply to a vast category. And yet they did not apply this screen. Should Mr. Carney have recused himself from the vote on C-15? One moment. Mr. Thériault, can you lower your boom mic a little bit, please? That's great. Thank you. Who would like to respond to the question? Michael? For what I've understood of that tax credit, it's for taxpayers. I had listened to the testimony by Mr. Sebia, and so it would be of general application for those nuclear plants. Well, he's wrong. There was a tax credit that was created for these small nuclear power plants and a new tax credit for clean energy, which did not previously include these power plants before. So we're not talking about a small indeterminate group here. It is, in fact, quite determinate. There are 5 players with Brookfield and Westinghouse. There are only 5 companies, yes, who can. In Canada or in the world? In the world, in fact. There are American companies, there are companies everywhere. I could name them if you'd like, but I believe that the screen should have been applied to Mr. Carney at that time because there's a direct link with his blind trust. The screen is applied to ensure that he does not make decisions that have an impact on his assets. This is a budget bill, so should he not have recused himself from the vote on C-15? You have made reference to many things regarding the nuclear industry and these small nuclear plants. I won't be able to respond right now, but you can write the question to me and I would give you a response. The interpreter regrets, but both people are speaking at the same time. For the interpreters, please do not speak over each other. You have 10 seconds left, Mr. Thériault. Well, how is it that if they're constantly communicating with you, how is it that they didn't verify with you in this specific case whether or not Mr. Carney should have recused himself? How could they have decided the way they did, given the ability that they have to ask for your advice? Thank you. Can I respond? If it's a very brief response, that would be fine. Because we have a lot of questions and we don't have a lot of time. Mr. Hardy, you have 5 minutes. Thank you for being with us today. 2 weeks ago, there were some big announcements made in Alberta on 5 topics that I would like to raise today. Carbon capture. Were you consulted? Was the screen used? The consultations are confidential. And so we could not have been consulted on the content. So regardless, we can't know whether or not you were consulted. So we have to base ourselves on the word of Mr. Blanchard and Mr. Sabia regarding the application of the screen. They are responsible for it. They can ask for our advice, and we give our advice, and whether or not they accept that advice is up to them, and sharing that is also up to them. So these are direct employees of the Prime Minister, and they are the only ones who can say to the public whether or not the screen was activated and whether or not they consulted you, because you as an external party are not able to disclose that information. Correct. Well, then how can Canadians trust a screen that is being managed by the direct subordinates of the Prime Minister? Because for Alberta, all of these decisions, Brookfield is there. Same thing for AI and data centers. Nuclear, Brookfield. Pipelines, Brookfield yet again. So Canadians can say, what's going on? And this leads me to my next question. The Prime Minister's direct company is involved, and we can't know whether or not they use the screen? You are focusing on the screen. It is a preventive tool. The Prime Minister must recuse himself. Let me finish. The Prime Minister needs to recuse himself if there is a conflict of interest. In order to help with that, we created the screen, and it is managed by Mr. Blanchard and Sabia. And so they ensure that the Prime Minister does not end up in a conflict of interest. And in order to do that, they can consult me, and I give advice. But you understand that our committee needs to ensure that the mechanisms are in place to protect Canadians. And we've heard here that Mr. Carney could manage things himself, that he is ethical beyond a doubt, but Canadians want to ensure that there is some transparency and a counterweight there, and that the only people who can prevent this conflict are 2 people who are directly linked to the person who is subject to this conflict of interest. So how can we decide that the current structure is sufficient if we don't even know when the Prime Minister was asked to recuse himself? Mr. Sabia and Mr. Blanchard need to prevent a conflict of interest. That's what their job is, to protect the Prime Minister and to ensure that there isn't a conflict of interest. But you don't trust them. I don't see why not. Because they're direct subordinates of the person who is in a potential conflict of interest. You stated that they need to protect the Prime Minister. Well, their job is to support the Prime Minister to ensure that there isn't a conflict of interest. Well, you use the word protect. But moving into my next question, we talk about general application. And it's a fine line right now. The head of Brookfield stated that when Brookfield increases its profits, so does the Prime Minister. So how do we know if the decision was influenced by a potential private increase? How do we know when that line has been crossed? In 30 seconds or less, please. The Prime Minister makes a decision of general application for Canada's well-being. Well, that's fine. If he does something that only benefits himself, then it's not okay. How do we decide if it's of general application or not? Well, currently there's no way to know. We don't know. That's what you're saying. Thank you, Mr. Hardy. Mr. Sari, you have 5 minutes. Hello, and thank you for being with us. On behalf of members, I would like to note that you speak French very well, and we understand you very clearly. And I greatly appreciate the fact that you have been answering our questions both in French and in English. I have 5 minutes, and so I want us to have a bit of a rapid-fire conversation. I want us to be clear for Canadians listening to us. We understand what we're talking about here, but we want to ensure that we have the trust of Canadians. And so if we could simplify, because there are things that can be said that might undermine Canadians' trust. How can we ensure that we are proactive? How can we let Canadians know that we are acting proactively? The Prime Minister and I'll use him as an example. He put all of his assets into a blind trust. He cannot give any instructions regarding that trust. We want to avoid that he makes any decisions that would have an impact on what he has put in the hands of a trustee. That is why we implemented that screen. We say to him that he cannot make a decision that would benefit companies with which he has certain interests. And we tell him that there are situations where he would need to recuse himself, that he would need to declare it, and we have Mr. Sabia and Mr. Blanchard who will ensure that you do not end up in a conflict of interest. Thank you. We've heard from many experts in the field, and they told us unanimously that we have a system that is among the best in the world. And our system is not perfect because things change. But we can say that there are improvements that can be made, but there currently aren't any loopholes with Brookfield. Can you please repeat the question? Of course. Are there any loopholes that would allow a public office holder to skirt around their ethical obligations for any public office holder? Are there any current shortcomings? As I stated earlier, we want to make minor improvements, but if we compare ourselves with other countries, for example, the United States or other countries, we have a great system. Look at the conflicts of interest. They are few and far between, and there were no situations where somebody got significantly richer following a decision that was made. Regarding conflicts of interest and the code of conduct, are there elements that could keep people from joining the public service? An appearance of conflict of interest is at the heart of this. That's what's important for Canadians. For an elected official or somebody who is appointed, it can be difficult to manage the appearance of a conflict of interest, and you have to strike a balance. That's why we recommended certain changes that, in principle, one needs to avoid an apparent conflict of interest.
Followed by Mr. Maloney for 5, Mr. Thériault pour 2 minutes 30 secondes. And then I'm going to suspend for a bit just to take a bit of a break, and then we're going to come back with the reset of the clock for the second hour. Mr. Barrett, go ahead, please, 5.
Commissioner, I want to circle back to our conversation about the Budget Implementation Act. I'm going to read an excerpt to you from it. Quote, "A minister may, by order for a specified validity period of not more than 3 years, and on any terms that the minister considers appropriate, exempt an entity from the application of a provision of an Act of Parliament, except the Criminal Code, if the minister is responsible for the act, and specifically that, quote, the minister may exclude information that, in the minister's opinion, would be inappropriate to make publicly accessible for reasons that include safety or security considerations or the protection of confidential or personal information," end quote. It seems to me that there's an absence of safeguards here, because we're looking at the opinion of a minister to make a decision about whether or not to allow for the publication of a decision to create an exemption to an Act of Parliament. And for the same reason that it ought not to apply to the Criminal Code, I posit it ought not to apply to the Conflict of Interest Act, and the same to the Lobbying Act. And I'm interested in your opinion for the very reason that this matter is under consideration before the House, and frankly, this stands to limit your ability as an independent officer of Parliament to discharge the watchdog role that Canadians expect you to be able to discharge.
This is your interpretation of C-15, and undoubtedly, if C-15 in its present form is enacted, this particular issue will be litigated on some point in time. And I hear you what your interpretation. I'm not sure I necessarily agree with it, but as I told you before, it's not an act, and I didn't expect to be asked for you to comment on a bill that's before Parliament. But once it is enacted and fully, I certainly do not see that the action under that act and the provision that you act automatically protect you from the Conflict of Interest Act and allow you to take decisions which benefit you. Well, not you, I mean, the person involved.
Yeah, I think the core problem is, and the reason that I raised this with you today, is that we have an opportunity to address this before the matter is voted on by members of the House. I think that a minister could legally conceal information that you need to assess whether a conflict exists, and that's the fundamental problem with this provision.
Yeah, I understand your position. As I say, well, undoubtedly this will be litigated if ministers take that position. And we will see what the courts have to say. Or else, since the bill is still in committee, you can amend it before it gets passed.
I mean, we would litigate those issues if we knew, if we were to ever know about the decisions that were taken. And that's the problem with secret orders. I have just over a minute in this round left.
No, but on that point, again, I keep saying, if it is that is normally prohibited, but an exemption has been granted. Surely somebody is going to say, on what basis are you doing it? The Act says no, and then it's the only answer the minister can say is because I exempted it. So it is not secret.
Well, it says the minister may exclude information that, in the minister's opinion, would be inappropriate to make publicly accessible for reasons that include personal information. It's a pretty broad scope, and who is going to test the minister's judgment? That's why decisions are to be gazetted. That's why they're published in the Canada Gazette. That's why we have reports tabled in Parliament. That's why we have independent officers of Parliament. It's so that we have transparency, and when politicians are able to take decisions in secret based on their opinion, then it seriously erodes the public's confidence, Canadians' confidence in our democratic institutions, and the executive should not seek, nor should they be given this level of power.
I'm going to have to
Two
leave it there.
things with your answer. A, what's personal information, how you determine that. And secondly, if your scenario is true and plays out, etc., then the electors will have a negative affection, and the electors can obviously remedy the situation. So, I mean, it is a pretty risky scenario that you paint here, that somebody will deliberately do this in order to protect their conflict of interest.
If you give a monkey a loaded gun, whose fault is it when someone gets shot? The person who gave him the gun or the monkey?
Thank you, Mr. Barrett. Thank you. Mr. Maloney, go ahead. I'm going to stick to the strict timelines here. I have to, just to make sure we get everything in, okay? Go ahead.
I won't take that personally, Mr. Chair, but thank you. I'd like to first of all thank you for being here today. You have a very demanding job, and today is an example of the patience required to fulfill your role. So I just want to express my gratitude. Look, I'm going to go off topic here a little bit. Not off topic, but I'm going to change what we've been focused. The problem with the ethics rules and the Conflict of Interest Act is it becomes weaponized time and time and time again by politicians, which I find not only wrong but incredibly offensive. Mr. Barrett's talking about the integrity of the institution, the integrity of people. That weaponizing this process does just that. Now, so I can give you very specific examples of where the rules and reports have been weaponized to no end, and people regret it. We're supposed to be doing a statutory review of the legislation here. I've been here for 2 meetings. I've heard very little in the way of questions about amending the statutes. What I have heard is a number of allegations that have not been substantiated, proven, and there's no evidence to support them, which is what undermines the integrity of the whole process, because what you see here is a bunch of allegations throwing around the Prime Minister's name quite loosely, and there has been not one iota of evidence or proof to substantiate any of this, and it's not what we're here to do, which takes me to what Mr. Barrett was talking about. This provision in C-15, and I'll quote him, quoting the bill, it says, if the minister is responsible for that. Now, here's my first question. All of these screens and ethics screens and processes are put in place before a position assumes a role or immediately upon assuming the role, i.e. when you get elected or when you get appointed to cabinet, correct? Okay. Nowhere has Mr. Barrett suggested that in this proposed legislation, that would imply that a cabinet minister could then go back and amend the ethics legislation to exempt him from anything, because it's not in there. In fact, his language says, if the minister is responsible for that act. The legislation we're talking about falls under the jurisdiction of the President of the Treasury Board, correct? Right. So the defense minister and the finance minister and any other minister could not, in any conceivable fashion, put forward a piece of legislation and therefore exempt themselves from any requirements under the Ethics Act. Is that correct?
Yeah, absolutely. You're talking about a quotation that Mr. Barrett read. I don't have it in front of me. I don't see anything. But if you, as you stated, if it's the exemption can only be done by the minister responsible for the act, that minister is not responsible for the Conflict of Interest Act. You're absolutely right.
Correct, thank you. The other reference he made was it can withhold information, but it's not the minister, his or her personal information we're talking about. It's information related to the subject matter or whatever piece of legislation might be before the House. So again, it's a mischaracterization of what is contained in C-15. Now, so my question, I guess, really what I want to know from you, do you see a way forward so that the government or the House of Commons can amend this legislation so it can no longer be weaponized in a way that undermines the integrity of me and everybody sitting around this table and every person in the House of Commons?
Minute and 10 seconds.
I have just now given an interpretation which suggests that it can't be done in any event. But I mean, clearly you could make an exception to it, saying any act of other than the Conflict of Interest Act. You could just put that into the legislation. That would solve the issue.
Correct. That would solve the alleged issue raised by Mr. Barrett, which actually isn't in C-15. Yeah. But my question, can you think of anything else, any other provision in the Act or Acts that would prevent, or there'd be consequences for weaponizing this process?
I don't know. You call this weaponizing. What really, if we have the Conflict of Interest Act the way we have now and we administer it, it's really, I think, generally regarded as being neutrally objectively administered, and we have remarkably few conflicts of interest in this country of issues of breaches, and other jurisdictions come and talk to us. How can it be? How can we learn from you and can adopt a law similar to yours? The weaponization is. Part of it is a normal political process of debate and partisan dialogue. I don't think you can deal with that legislatively.
Monsieur Thériault, 2 minutes 30 secondes, s'il vous plaît. Commencez. 2 minutes 30 secondes.
Mr. Thériault, you have 2 minutes and 30 seconds. Thank you. I asked Mr. Sabia and Mr. Blanchard how many times they had asked the Prime Minister to recuse himself. They corrected me. They said they don't ask, that they force him to recuse himself. And Mr. Blanchard stated that he told the Prime Minister not to meet with the people that were on his declaration. And I asked him whether or not that applied to telephone communication. His answer was to say no. Mr. Carney has the highest standards for himself. I find this answer quite confusing. So I understand that he's not told not to have phone calls with these people. Mr. Carney probably has an address book that is full of names because he understands his obligations. And if we were to apply that same logic with the blind trust, well, there wouldn't have been a blind trust because we would have said he knows his obligations and he self-applies the highest standards to himself. Does this not show a lack from Mr. Blanchard regarding the application of the screen? And does it not also show that the Chief of the Privy Council is not the right person to be managing such a screen? You have 55 seconds. You said that the screen does not apply to phone calls. I did not see the reference, or I have not heard the reference that you quoted. If Mr. Blanchard or Mr. Sabia know that Mr. Carney was going to speak to Brookfield, they would say, no, we need to use the screen. You can't do that. I'm surprised that you're saying that the screen would not apply. Apologies. Your time is up. It's in the blues and could be verified. Thank you, Mr. Thériault.
And then I'm going to restart the clock at the top of the hour.
Okay, so while they're just taking a quick little 5 or 10 minute break, we are going to tune into the House. Let's see what the House is up to.
North for his question. And he's given me a chance to talk about something important. Filibuster. In the past eight months, I've learned about this filibustering. On the Transport Committee, the Liberal chair canceled 3 meetings, and at 4 other meetings, a different member spoke for 4 hours straight to save his government, hiding behind his minister. And you know what, Madam Speaker? We were talking about road safety. So filibustering is a waste of everyone's time and money. The Honourable Member for Abitibi-Temiskaming. Thank you, Madam Speaker, and I'd like to thank my colleague from Beauce for his speech. He ended saying that he was going to fight for people in his riding, and we know that if you look at his hockey stats, you can see, and I'm happy to see that the people of Beauce will be well represented. He talked about one issue among many that wasn't in the budget, and that is one thing, and that is cell service in rural areas. Why is the federal government ignoring that issue? It's a matter of public safety. It's a matter of economic development, regional economic development. And it's a matter of just making our regions feel that they're connected to the rest of the planet and that it shouldn't be a sacrifice to live in a rural area. Why is the federal government not investing more for something that should be an essential service? I'd like to hear what my colleague has to say about that. Now, member for Beauce. Madam Speaker, I'd like to thank my colleague from the bloc. My statistics might be a bit exaggerated. There was no Facebook back then. Coming back to cell service. In our riding between 2 towns, between Saint-Georges and Saint-Ephrem-de-Beauce, they're 20 minutes apart. And for 15 minutes in those 2 places, there's no phone lines. It doesn't work. So they're 20 minutes apart. And there are people that live in between these 2 towns. But in 15 minutes of that space, there's no cell service. So if you have an emergency, I don't know what's supposed to be done if there's an emergency. It's an excellent question. And I would ask the Liberals, why not invest? How big is the deficit? It's astronomical. Why couldn't there be a little something for cell service? But this is the typical of the Liberal government to ignore the regions. The Honourable Member.
Speaker, and I want to thank the Honourable Member for the speech. It's interesting, cell service, the highest paved road in Canada, has no cell service on it over the Kootenay Pass. Still, today, one of the most dangerous roads in Canada. But my question is actually related more to the credit card, where we have so many people relying on credit cards and the interest payments are becoming unmanageable, where they can't even afford to make the payments, which is sort of what this government's doing. When you don't have a solid economic growth, you end up having a hard time paying your debt. So we have sawmills, for example, that are using a line of credit to pay their staff. Well, that's not sustainable. They'll be having to shut down that sawmill. So my question is, how do we now move forward so we're not having a credit card budget to where we're actually making some real payments and supporting Canadians?
A very short answer. The Honourable Member for Beauce. 15 seconds. Thank you, Madam Speaker. And I'd like to thank my colleague. It's simple. We should be making life affordable for Canadians. Thank you.
Resuming debate, the Honourable Member for Egmont.
Thank you, Madam Speaker. It is always an honour to rise in this House to speak on any issue, but in particular a budget. And this budget, Madam Speaker, strikes the balance that Canadians were looking for in the recent election. When I was campaigning, voters were telling me they wanted to see government get smaller. They wanted to see government reduce its costs, reduce its size of government, but at the same time, Madam Speaker, they wanted to ensure that government was going to protect those social programs that Canadians cherish and look to so much across this country. So, Madam Speaker, I certainly will be supporting this budget because this budget strikes that balance. It's a budget that invests in those programs that support our seniors, that support families, and that supports those that are facing hardships. And Mr. Speaker, Madam Speaker, it's important that those watching the proceedings of the House of Commons clearly see the difference between the conservative ideology and liberal ideology. Liberals will always support those programs that Canadians depend on. And there's nothing, Madam Speaker, more glaring than in the area of senior pensions. And I've been listening to speeches in this House over the past number of months from the opposition about the cost of living and the impact on those vulnerable seniors, primarily seniors. But if it was not for this government, then if you were a senior age 65 to 67 today, Madam Speaker, you would be living with $22,140 less, because this was the group of people that a former Conservative government decided did not need the support of the old age pension program or the guaranteed income supplement. Think for a moment, Madam Speaker, if you're in this age category, how would those costs that continue to go up would be impacting you without this particular amount of money? At the time, Conservatives felt that it was not important that seniors in this age category be given this public benefit, the benefit that they worked so hard for over the years. This is just in old age pensions. The Canada Child Benefit, Madam Speaker, was one of those programs that our government in the early days brought in that I'm most proud of, because it fundamentally changed the lives of many families that were living and struggling financially. And I can give case after case, Madam Speaker, of families that tell me how important it is to them, how it allowed them to participate, their children participate in programs that they could not do before. There's the child care program.
Okay, we can turn this off. The committee's back.
Brookfield portfolio company that is subject to the ethics screen. Did Mr. Carney or his office contact you prior to meeting with North River Midstream?
As I told you before, any conversation I have with Mr. Carney, etc., is confidential. If there's anything made public, it's from him, not from us.
Thank you for that. But we know that Mr. Carney was lobbied by North River Midstream. Mr. Carney, on May 6th, a week later, met with Sam Pollock, the CEO of Brookfield Infrastructure in Washington, D.C. Brookfield Infrastructure is also subject to the ethics screen. It has recently come to light that in October, Mr. Carney met with the Chief Operating Officer of Brookfield, Justin Bieber, in the Prime Minister's office. So here we have a pattern of Mr. Carney meeting with top Brookfield executives who have direct access to the Prime Minister, as well as Brookfield-owned companies. Is this what you envisioned when you set up the ethics screen?
I wish you would not focus on the ethics screen, but understand the system of it. The system is clear. If there's a conflict of interest, the Prime Minister has to recuse himself, and his recusal is made public. That is the basic rule. To help him live the opposite, because he's a busy man and he deals with thousands of issues. The office has established a screen to try to make sure that he doesn't get exposed to it. And that's what the process. So you're asking me what the screen has to do?
The conflicts involving the Prime Minister are so vast with respect to Brookfield that you saw it necessary to implement a screen as a precautionary measure. And yet, and Mr. Sabia said that you told the Prime Minister to basically stay away from Brookfield. And yet, here we have the Prime Minister meeting with the Chief Operating Officer, being lobbied personally lobbied by one of the major Brookfield companies that is on the list of companies that is captured in the screen. And I'm asking you, does that not raise questions about whether, in the face of all of Mr. Carney's conflicts, Brookfield has a direct line to the Prime Minister?
The incidents that you recited just now, would you please recite them again? Which ones are you talking about?
North River Midstream. Prime Minister personally was lobbied by them. He met with Sam Pollock.
What do you mean by he was personally lobbied by them?
He was lobbied by North River Midstream on April 30th. They met with him. And on May 6th...
But I'm sorry, when you say he was lobbied, there's
a disclosure of that.
Disclosure under the Lobbying Act that they made a representation to Mr. Carney?
That's right.
Okay. Go on.
He didn't even know that.
Mr. Pollock, the CEO of Brookfield Infrastructure, and then in October, the Chief Operating Officer of Brookfield. It certainly seems like he has an awful lot of contact with Brookfield, and not just anyone from Brookfield, but the CEO of Brookfield Infrastructure and the Chief Operating Officer of Brookfield.
And this was prior to the election, after the election?
It was after the election. All of these were after the election.
All of these were after. Yeah, I mean, you know what the rules are, and how this screen is established to prevent everything, etc. You're talking about the meeting with Mr. Beaver, etc. I understand from the Prime Minister, from Mr. Beaver's testimony, that this was about anti-Semitism. It had absolutely nothing to do with business, and that it was a personal visit, etc.
I don't
Should it have
that.
taken place or not? You should have. That's for you to decide.
Well,
it's really, if they talked about anti-Semitism, it's clearly not.
Certainly North River Midstream wasn't about that, and nor was the meeting with Sam Pollock in Washington, D.C. I would submit, and I think most Canadians would agree, that it would be a heck of a lot better if the Prime Minister just stayed away from Brookfield, but that isn't happening. Now, on September 27th, while in London, England, Mark Carney attended a working breakfast with Canada's High Commissioner to the UK and 8 international investors. Did you sign off on that meeting, having regard for the list of attendees?
I don't sign off on meetings, and as I keep telling you, I give advice, and the advice is confidential. It's up to the Prime Minister to disclose it or not.
Well, Mr. Carney's chief of staff came before this committee and testified that you had been made aware of that meeting and that you signed off on that before it took place. Is that accurate?
He did. Okay, fine. Yes, we did. I mean, that was a general meeting with investors as part of his duty as a Prime Minister in being in the UK and trying to encourage people to invest in Canada. So yes, I asked it, but I mean, this is one case where they disclosed my advice, and that since it's up to him to disclose, I can comment on it.
Okay, thank you, Mr. Cooper. Madame Lapointe pour 6 minutes.
Ms. Lapointe, you have 6 minutes. Thank you again for being with us today and for responding to our questions. We've been focused on this study for a while, and some witnesses have said that the exemption for the general application should be removed. Would that stop people from fully exercising their role? Michael? The exemption for general application can be found in ethics regimes throughout Canada. It's a pretty uniform measure throughout provinces, and it's there for a reason. If a public office holder makes a decision and happens to have an interest, just as any other people impacted by this decision, well, that decision should be exempt. We're saying that that person is acting in the public's interest and not in his own interest. In your most recent report, your most recent annual report, you proposed a few amendments to the legislation. Can you share with us what changes you would like to see regarding aligning the Act and the Code of Conduct for members of Parliament? We would like to add an appearance of conflict of interest. There is something that applies to members in the code, and so they need to avoid these apparent conflicts of interest, and that's not in the Act. It only includes real conflicts of interest. I would suggest that the changes be made because for Canadians, an appearance of a conflict of interest is significant. And appearance of conflict of interest can undermine the public's trust in government. That is why I believe that we should align the code and the Act. Thank you. Your suggestion to look at the appearance of a conflict of interest is made in order to maintain the public's trust. Are there any countries in the world that we could look to? In BC, for example, there's an obligation to avoid an appearance of a conflict of interest. We also looked at England, Scotland, and Holland. They have different words, but the same idea. That public office holders need to avoid an appearance of a conflict of interest. We often receive information on operations and legislative changes proposed by the government before they are made public. Should there be a strengthened code of conduct for members? When we look at the rules, the members are subject to the code and public office holders are subject to the Act. There are a group of individuals that are subject to both. It's always easier to have rules that are aligned because you know the rules that apply to you. And so it is always more clear to have rules that are the same for those who are subject to conflict of interest legislation. In Quebec and Ontario, that is a model that's used. There are rules for the different categories, but they follow the same rules. I think that it makes things clearer and more easily understood for those who are subject to these rules. Thank you. So, harmonizing the Act and the Code would be beneficial. In your view, what would be an appearance of a conflict of interest? We have an example
Linda, go back to sleep.
Regarding Mulroney and Schreiber. Judge Oliphant suggested adopting a definition and that we make an amendment to the legislation. Michael, could you read that, please? Certainly. I have the definition in English, unfortunately, but we're talking about the standard of a reasonable person.
Where there is a reasonable apprehension, which a reasonably well-informed person could have that a conflict exists.
Okay, thank you. Merci. Monsieur Thériault, 6 minutes, s'il vous plaît.
Mr. Thériault, you have 6 minutes. Mr. Thériault, 6 minutes. The floor is yours. Thank you. I would like to know if you carry out audits on information shared by public office holders regarding the activities of public office holders.
Holy crap, my ears.
Office reviews documentation that is shared by public office holders and members of parliament. These are two systems that are based on disclosures made by those who are subject to the rules. The office cannot communicate with the CRA, for example, regarding income taxes, or can't do credit checks. So the Canadian system is based on goodwill and the disclosure made by members and public office holders. Thank you. Commissioner, last time you came to see us, you stated that one of your three main goals is to look into allegations of conflict of interest with federal workers who are either appointed or elected. And so you would investigate when a red flag is raised. When the ethics commissioner from Quebec came to meet with us, she explained that she can investigate on her own initiative if she has a reasonable cause to believe that there were any issues. Would you like to have that opportunity? I already have that authority. How many times have you used it? Very rarely. If there's a case that raises any suspicion, often somebody will communicate with me and ask me to lead an investigation. I do have that authority, but I believe that I've only used it once. And regarding what I mentioned earlier on C15, would you take initiative and dig deeper into the situation? How do you apply your authority? I believe that you often wait for somebody to raise a red flag. And can you explain what the situation was that led you to initiate an investigation? Please read so at section 45(1), the commissioner can study a matter of his own initiative if he believes that a public office holder or former public office holder violated the act. Microphone, please. As you know, I was a former judge. If I read about a situation in the newspapers, I'll look at whether or not it needs to be looked into. Are there any suspicious indicators? And I ask myself whether or not it would be in the public's interest. There's no concrete test. It depends really on context. And I need to decide whether or not to look into it further. Well, if we want to include the appearance of a conflict of interest in the Act, I imagine that you might have to use that authority more frequently, and you'll have to analyze situations in order to not undermine the public's trust with an apparent conflict of interest. For example, when parliamentarians ask questions, I imagine that you would have what you need so that you wouldn't have to wait for a formal complaint. You'd be able to verify the facts, ensure there is accountability regarding the Prime Minister, for example. Or you could speak to the person involved or the department that's involved. Is that part of your tasks to ensure there is accountability when an issue arises? If Parliament adopts the changes that I have proposed regarding an apparent conflict of interest, well, that would include the definition that my colleague read for you. That would facilitate the implementation of the Act and for carrying out investigations, because currently it does not include an apparent of a conflict of interest. The Act requires that I need to have a suspicion that something is being done. Mr. Commissioner, the time is up. If you could answer very briefly in 5 seconds or less. We'll come back to this later. Mr. Hardy, you have 5 minutes. We're moving on to Mr. Hardy, Mr. Commissioner. Thank you very much, Chair. Earlier, Mr. Maloney stated that it's his second time being with us, and you probably have other things to do, but we talked about weaponizing ethics. So weaponizing ethics. But Canadians sometimes reach out to us, and perhaps I'll ask a question to Mr. Aquilino earlier regarding a person who is reasonably well informed. When Canadians reach out to us, I believe that they are reasonable and they are reasonably well informed. They shouldn't have the impression that we have better things to do and that it's a waste of time. So when I look at what we're dealing with, a very specific situation that we're seeing for the first time, and when I look at examples that come up in Parliament, and there's nothing new here, I stated it earlier, carbon capture, AI, data centers, nuclear, pipelines, the space agency that is 50% owned by Brookfield. So for people who are reasonably well informed, there could be an appearance of a conflict of interest at least. Do you believe that there is an appearance of a conflict of interest? Because that is what you're proposing that we change. So if we change the legislation, would you say in this case that there is an appearance of a conflict of interest? You are mixing a few things together. If the Act is amended and I can carry out investigations regarding an appearance of a conflict of interest, I'll do them individually. I'll look at all of the different cases and situations. But would you do it in the case that I mentioned? If we listen to you and we follow your recommendations, well, it would be my obligation to do so. So, you would. I am following up on your recommendation. I'm saying a person who is reasonably well informed, people at this committee, Canadians, are wondering why there isn't an investigation, because there at least seems to be a conflict of interest. Well, it's up to me to decide, not up to the person who reaches out to me. Somebody will explain the situation to me, or I'll see it myself, and I'll look at the facts and the context and decide whether or not there seems to be a conflict of interest, an apparent conflict of interest. And at that time, I would start an investigation. But Commissioner, this is being raised in Parliament. This is public and these are facts. I'm not inventing anything. 50% of the space agency is owned by Brookfield. This is a fact. We're talking about things that are public knowledge. Would you act if we were to add that appearance of a conflict of interest? I cannot answer your question. My team would look into it, and you're sharing isolated facts, and I would have the facts shared with me, and then I would make a decision after that. You have 2 minutes. So for you, you're saying that I'm sharing an interpretation of facts and not actual facts. Well, anyway, Mr. Sabia and Mr. Blanchard have stated that they communicate with you regularly. The first time you said that you came here, you said that you didn't want to be both judge and jury, and you didn't want to apply the screen. At what point do you become a part of the process? They say they have to call you every day. Is it because there are issues happening every day? And both of them said this during their individual testimonies. That's what they said. The only thing that I can say to you is that I answer their questions. If they call me, I answer. So if they call you every day, then there are things happening every day. As you know, we have a dedicated team for all of those who are elected or appointed. The Prime Minister's office speaks to the person that I appointed for the Prime Minister. Thank you, Commissioner. How many times have they called? It's up to them to tell you. Thank you.
5 minutes, go ahead.
Thank you. I wanted to go back to Mr. Cooper's statement that Justin Bieber met with the Prime Minister. The statement that he made to this was, since Prime Minister became Prime Minister, there was absolutely no communication between Brookfield and Prime Minister. Yes, Justin Bieber met as a private citizen in his office once. Is there anything wrong with that when they state, since Prime Minister became Prime Minister, there was absolutely no communication between the Prime Minister and Brookfield?
As Mr. Beaver said, he was there not as representative of Brookfield, but in his personal capacity to speak about anti-Semitism. That's obviously his right, and he can do that. It would have been more. It's unfortunate that this was done in just the two of them in the office with the Prime Minister. It would have been, I think, better if he had met in a group with the Prime Minister to talk to him, so that one couldn't make the inference that some people are making that this is a contact by Brookfield.
Thank you. When Prime Minister ran to be the leader of the Liberal Party and the Prime Minister, the country knew who he was. They knew that he was leader or he was chairman of the Brookfield Corporation. They still voted for him and elected him. Do you want a country where a successful person should be excluded because they are successful in their private businesses? And my friends on the other side seem to oblige, or they want us to go through that process, that only people who have done absolutely nothing should be the leader and the Prime Minister of the country.
Give me the act, please. The act specifically suggests that we... Which section is it? Yeah. This specifies what's the purpose of the act and establishes a clear conflict of interest, but minimize the possibility, provide conflict of interest commissioner with a mandate and then encourage experienced and competent person to seek and accept public office, facilitate the interchange between private and public sector. It's specifically set out in the law, and which means make sure that the most talented and able people can come into the public service in and out without conflict of interest, or if there is a conflict, manage it. I see that as my mandate, and so therefore, the fact that the Prime Minister was a very successful businessman, a former international banker, and a president of the Bank of Canada and UK, those are positives. That's a competent person. That's what I'm supposed to make sure. But I also have to make sure that he has no conflict. And so therefore, the more experienced, the more talented somebody is, the more difficult it becomes to apply the act. But that doesn't mean we won't do it, or that we discourage good people to enter. Just the opposite. We want the best people to enter the public service.
During the appearance before the Ethics Commissioner, Quebec Ethics Commissioner Ariane Magnot made the following statements. As a society, we have chosen to give Commissioner the responsibility of ensuring that public office holder and member conduct themselves in an ethical and professional manner. We must trust them and give them the flexibility they need to carry out their duties independently and impartiality, taking into account the circumstances of each situation. Do you agree or disagree with the Commissioner from Quebec?
I fully agree with what she said.
Thank you.
25 seconds, Mr. Saini. 25 seconds.
Can you describe how your office ensure uniformity in decision-making so that all parliamentarians are treated fairly and consistently?
Quickly, Commissioner.
Lynn, that's up to you.
So my team is responsible for providing guidance to all parliamentarians and public officials, and we have a practice manual, an internal practice manual, where advisors, I have 10 advisors who provide guidance to all these people consistently. So those rules that are written there that have been sanctioned by the Commissioner,
Thank you, Ms. Robinson.
they provide guidance based on that.
Thank you. Monsieur Thériault pour 5 minutes.
Merci beaucoup.
Thank you. Commissioner, if I can summarize our previous discussion, I understand that if we were to include in our legislation your suggestion to cover the appearance of a conflict of interest, at that time, then you would have an additional tool in order to investigate potential cases of conflict of interest, which is something that you are not currently able to do, which you would be able to do. Do you agree with that summary? Yes. I quite appreciated the answer that the Quebec Commissioner gave me regarding public office holders that are able to participate on decisions that would have that are for the public interest. She said, "It is important to ensure that a personal interest does not compromise one's independent judgment. The matter is not knowing whether or not legislation applies to a large category of people, but rather to know whether or not a person's judgment could have been influenced." Do you share that point of view? Yes, I do. And so, we're saying here that objectively, there could be situations with a general application decision, but because of the context and because of a person's background, there could be an appearance of a conflict of interest. And at that time, we would have to implement requirements that would be strengthened in order to better include the work of that person. Do you follow? Now you're talking about a situation where the legislation would be amended and includes the appearance of a conflict of interest? Is that the context that you're giving me? Yes, if we know that we're dealing with a general application decision and it could have an impact on one's assets. And so, with the tool that you have proposed and including an apparent conflict of interest, well, we have to recognize that there is an appearance of a conflict of interest, even if it's of general application. And at that time, there needs to be tools in order to govern such a situation, in order to avoid that there would be the appearance of a conflict of interest. I reformulated my question. Yes, I understand. I don't think that we need additional tools. I think that with the legislation that we have and the interpretation that we've had, it's quite clear what a person can and can't do in order to avoid a conflict of interest. Well, currently, you cannot act. And there's no tool other than the screen being applied by subordinates. So you also don't have tools regarding an apparent conflict of interest, and you've stated that you need that tool in order to increase the public's trust towards its democratic institutions. So it's not enough to say that it's a general application decision, so there's no conflict of interest. We need to dig further. There could be an apparent conflict of interest. And so focusing on this would give you additional tools in order to do the work that you need to do in order to ensure accountability. If there's no proof of a conflict of interest, your search for accountability would stop there. Thank you.
Je vois pas qu'on va seulement.
If there's an appearance of a conflict of interest, well, that's an additional task. There could be a very minimal conflict of interest, but it leads to the appearance of a larger conflict of interest, and that could undermine the public's trust.
Time for Mr. Barrett, followed by Mr. Saray, and I think we're going to go back to Mr. Cooper for 5, and then we'll finish it off over here for 5. Mr. Barrett for 5, go ahead.
I want to touch on the question of the list of 2,000 companies. There's 103 that are on the screen. That information was not, as I understand it, initially provided to your office. And the question that I hear from people is, why aren't those other companies on the list? Mr. Cooper said, it's 95% of the companies on the list. So, how do we have confidence that the screen is complete, that it's working, if 95% of the companies are missing?
You have here the names. We were furnished, obviously, with the interest of Brookfield or Brookfield Asset Management or etc. in those companies. And so on that basis, we can those are given to us confidentially. It's such a long list, but most of them, as Brookfield pointed out, it's a minimal interest.
So that's interesting. I mean, these are huge companies, highly successful. Brookfield doesn't really seem to be in the de minimis business. So how are we defining de minimis? Wouldn't it just be easier for you to include the companies as part of the screen?
You include them if there's a likelihood of if they're being affected by a decision. Yeah, I don't know how else to explain it. If we make the decision saying, seeing the interest in those companies and saying,
Did you say previously you don't have the full list, though, sir? My question is, if you don't have the list, how can we make a determination? How can you make a determination if?
I'm
if
sorry.
you don't
What list
know?
are we talking about? Are you talking about Annex A of the screen?
Well, no, we're talking about the 2,000 companies that in Mr. Bieber's testimony he referenced, and then later in his response to the committee that you were aware of. I inferred from your response, you're aware of his response, that these companies were referred to as de minimis. Well, are you to take them at their word? Or would it not be in the public interest to just to include the totality of the entities that might create a conflict, where Mr. Carney may stand to make money from decisions that he takes that benefit those companies?
I'm sorry, you're losing me. We are looking here at the conflict of interest scheme of Mark Carney. It's by him. He testified. He in effect signed this, and he lists saying these companies. He suggests that here he had a management position or oversight role in the activity prior to Jennifer, and he lists 25 of those. After number 5, 6 to the end are basically subsidiaries or part of the Global Transition Fund, and that's why they're listed here.
Okay.
And then he also lists other companies that have been lobbied. So I don't understand where the 2,000
I'm limited on time. I want to circle back to the question that another member asked about depoliticizing, de-risking this for Canadians. We've said before, I have said before that I believe that the sale of controlled assets by someone who seeks to be prime minister, is it complicated? Absolutely. But is it possible? As confirmed in this case by Brookfield? Absolutely. And as mentioned by a previous witness at this committee, there are steps to take. I mean, the cost of the administration of the screen is covered, it's paid for by the taxpayer. So too could the government waive the tax liability on the sale of these assets so that we don't have this question. Is it 95%? Is it 100%? Shouldn't they just sell these controlled assets and we can continue to attract good people to public office?
20 seconds.
There's also a question of the valuation, not only tax liability. Lots of these are future earnings that will be determined on the performance of Brookfield. How do you value those?
Even Brookfield said that they could arrive at that, and I think that when we're talking about the public's confidence in our democratic institutions, we should be able to figure out the tough questions so that we can avoid the murkiness that seems to persist here.
Thank you, Mr. Barrett. Monsieur Sarri pour 5 minutes.
Merci beaucoup, Monsieur le Président.
Thank you, Chair. I've been thinking about the quote that we need to think about strategies and that lower minds think about lesser things. But anyway, this is not necessarily the best debate in order to have better strategies. If we want to frame things well, we need to think about strategies and not focus on individuals. Whereas here, we're speaking about only a specific person for a while. I'm quite proud to be a part of this committee, And I would have liked us to look at the mechanism instead of a specific person and propose solutions and not personify this debate. I did not want to politicize our debates. And for those who are listening to us, that's why I want to simplify the things that we're talking about, because our discussions could undermine the public's trust. There are people here who have a career in politics and would still undermine trust in undermine the public's trust in its institutions, and that's unfortunate. There are experts who say that the ethics legislation works because it applies institutionally instead of on a case-by-case basis. Can you confirm for Canadians who are listening to us that the mechanisms that we have in place for the office of the Prime Minister do not seek to protect a particular person, but to ensure there is stability and neutrality and transparency for government? The way you expressed that was very eloquent. Thank you. And I agree. Thank you for that brief response. It gives me the opportunity to speak to Canadians. I want our institutions to be proud to be Canadian and proud to serve Canadians. And personalizing this debate and speaking about the Prime Minister, who, by the way, was chosen by Canadians, undermines our discussion. And we want to talk about ethics and perception, because politics is perception, and playing political games on things that aren't facts is dangerous. And this brings me to another question. The environment that we're working in changes very rapidly.
Are you going to ask a question,
Things are more complex. Could you help us, because you do have some expertise? The mechanisms that we have in place need to be updated. That's a fact, and that's why we're looking into it. Could we reassure Canadians and say that this would allow the Prime Minister and his team to work efficiently and respectfully, all while following ethical legislation? We apply the legislation to ensure that everything is done correctly, and we want to give flexibility so people can work for Canadians. And we're talking about national interest and a personal interest with the Prime Minister. How can we define, or how can we state that decisions are made in the public's interest? You have 10 seconds. Lynn? 6 seconds. When we look at national interest, we're talking about the public's interest, and the law includes a mechanism for recusal if we're focusing on the personal interest and not the public's interest. Mr. Cooper, 5.
Thank you, Mr. Chair. Commissioner, does Brookfield provide you with an update of their new investments and acquisitions? So there's no mechanism in place. Have you thought about perhaps reaching out to Brookfield in light of the fact that as Brookfield's portfolio changes, potentially new conflicts of interest involving the Prime Minister could emerge?
But Brookfield is not subject to the Act. The Prime Minister is, and his interests in Brookfield are, but not what the Brookfield itself.
Right, and his interests are? they're tied directly to Brookfield, which could be impacted by certain acquisitions that Brookfield makes over the course of time. And I'm asking you this in the context of ensuring that this is a living ethics screen, not a stale dated ethics screen.
But I have no power to ask Brookfield to disclose what they're doing, their business strategies, their acquisitions, etc. All I can deal with is what's in the public domain and what has been disclosed.
I understand that your official powers under the law might be limited, but have you reached out?
No, I have not, because I think it behooves me to act in accordance with the Act, not to add to the Act or use the position of my office or the authority in order to obtain information to the truth I'm not entitled.
The mandate of your office is to ensure that there are not conflicts of interest, and if there are conflicts of interest, to investigate those conflicts thoroughly. And it seems that on top of 1,900 Brookfield companies being missing from the ethics screen, we have the potential, which is about 95%, it may be in a matter of time that 97, 98% of Brookfield companies and businesses are not captured in the ethics screen, which raises questions about the robustness of the screen. I would argue that it raises questions that it is deficient. Now, Mr. Carney stands to make tens of millions of dollars in carried interest payments, in other words, future bonus pay from the multi-billion-dollar Brookfield Global Transition Fund 1, which he registered in the offshore tax haven of Bermuda. I understand that you're aware of the holdings within that fund, but are you aware of the limited partners, in other words, the investors in the fund?
Investors in the fund? No.
Request this information from Mr. Carney?
We ask him of information which relates to his holdings and his interests. The other, and he points out that he has an interest in Brookfield, and part of it is in Brookfield Global Transition Fund, which will as you say, has a deferred benefit provisions in it. I don't know on what relevance it is for what the other partners is, why I would ask for that.
I think it's material to know who invested in Mr. Carney's future bonus pay. These are, after all, investors that Mr. Carney would have personally sought out when he set up the fund. These investors represent potential conflicts of interest, and I think more broadly, it's in the public interest to know if Mr. Carney is beholden to who? To the Bank of China, to the Qatar Investment Fund? We don't know. So, again, I put it to you that it is material.
We're using the word beholden. I don't know on what basis you use that. There may be other people and they have invested in the fund. That doesn't mean you're beholden to it. So the whole implication of this is that there's something illicit or not proper that requires investigation. I can't do that.
I don't think that's a fair characterization. I think that what we have is a prime minister who was involved in setting up a fund. There are investors that he would have reached out to, and he stands to make a lot of money potentially in future bonus pay. And all I'm asking is whether there has been all of the disclosure that is necessary. Not necessarily all of it being in the public domain, but that your office has received the full cooperation of the Prime Minister in sharing all things that are material. And I think that the limited partners is something that is material, but it sounds like the Prime Minister's office hasn't been forthcoming. It seems like the Prime Minister has been very limited in what he has disclosed to you. I find it shocking that he didn't, for example, provide you with a list of 2,000 companies, but he would have given you 100 free companies, and you would have said, okay, that's it. There's no need to look any further.
Thank you, Mr. Cooper. Mr. Maloney, 5 minutes.
Thank you, Mr. Chair, and thank you again to the witnesses. The accusation period is almost over. Mr. Barrett again raised a topic I find quite intriguing. He suggested that elected officials dispose of all of their controlled assets and be sheltered from the tax consequences. I'm sure that would be enticing to a lot of people to run for office if they knew they could dispose of all of their controlled assets and not face any tax consequences. Do you think that's a realistic proposal, sir? No? Okay. I knew the answer, but I thought I'd ask the question anyway. It's absurd in the extreme, actually. I don't think Canadians would find it appropriate all that taxpayer money was using to absolve or to pay the taxes for elected officials. On Mr. Cooper's point about voting on things that could, ultimately benefit somebody, all of the Prime Minister's assets are in a blind trust, correct?
Yes.
Right. And as of the date that blind trust is created, he no longer knows what is contained in that or how it is being handled or how those affairs are being conducted, correct?
Correct.
Okay. Other members of Parliament, on the other hand, and there are many of them, own shares in a variety of corporate entities, including Brookfield, and they're voting in the House of Commons knowing they own shares in these companies. Is that correct?
Yes.
Okay. I'm just pointing out the irony. There really is no question there. Look, I'm going to go back to this political weaponizing of this process, which we've spent 2 hours here doing again, because there's all these allegations. Sir, you sat as a federal court judge for a number of years. I practiced law for 20 years. There are consequences to actions when you go into a courtroom, and there are cost consequences. So if you make false accusations, if you make false representations, if you are unsuccessful in those, there are consequences that come in the form of financial payment. So I asked you earlier, but we ran out of time. Is there a process you can conceive of where people continue to weaponize this process politically simply to score cheap political points? If there is a finding that there is no basis for the accusation or complaint, is it not possible to come up with some sort of mechanism to discourage that behavior so that there are consequences?
Well, you're running here into the whole issue of parliamentary privileges. And as you know, any deputy can say whatever he says in the House is not actionable, and it has no. So unless you really want to go to the whole core of the parliamentary system, and I don't think there's anything you can do. What members of parliament say in the House of Commons is privileged, and this is their opinion, and they're entitled to do that. And if it mounts to weaponizing, as you call it, that's their privilege too.
I don't disagree with you in that they're entitled to conduct themselves in that way. But do you not think, let me put it another way then, do you not think it would be appropriate when you or your office is issuing a report to address the issue of making these things political as they are? I mean, you could do that without breaching privilege. I mean, simply pointing out the fact that that an accusation or an investigation was requested and there's absolutely no foundation for it whatsoever, you could conclude that this was done for political reasons, could you not?
Yeah, if I wanted to, I presumably could. I doubt that I'd go that far as you suggest. What I might say is that, there were accusations made, but there's no basis for them, and my investigation has revealed that they're baseless. I don't think it's my job to get into the political arena. It's my job to be objective and to deal with issues of conflict of interest.
And thank you for saying that. I'm going to stop there, sir, because I think you've displayed today, time and time again, over and over, with every question answered, that level of objectivity and independence. So I just want to say thank you to you and your colleagues for taking the time to be here today and answering all of our questions. Thank you, Mr. Chair.
Thank you, Mr. Maloney. I want to thank the Commissioner, Ms. Robinson-Delpy, and Mr. Aquilino for spending time with the committee today. I have no other business. The meeting is adjourned.
Okay. So I've put the link in chat a few times, but we've got about just a little over 45 minutes to break, and then we watch question period. No Carney today, but we will definitely have Pierre Poilievre there. We'll have a lot of, front bench Liberal MPs, so we'll take a bit of a break and tune into that. And just before we go, thank you so much, Cindy and Wee Cookie, for the super chats. I really appreciate you guys and everybody tuning in and watching. But yeah, here's the link one more time, and I will see you guys shortly. See you guys.